90. Whilst the bar at preliminary hearing is a low one, there is still a requirement that the court is satisfied to a high degree of probability that the person poses an unacceptable risk of committing a serious terrorism offence, if not kept under supervision under the order. Section 24(7) of the Act requires the court to dismiss the application if the supporting documentation does not justify the making of an ESO, an extended supervision order. When the matters set out in S25(3) are considered, particularly noting the nature of the type of activity the defendant has actually engaged in, all there is comprises a generalized risk of making offensive YouTube videos and/or speculation about what other people might do when they see such material. 91. It is important to note that the defendant would be subject to the parameters of a CTO to manage his mental health issues, which can be renewed as many times as necessary, as well as the Commonwealth Recognizance Release Order in place March 2022. These items have the role of greatly curtailing any risk that the defendant will commit an offence. 92. The current information regarding the defendant is that he is no longer expressing adherence to UKOA philosophy. This should be seen as, at least, some evidence of decreased risk regardless of the caution expressed by the treating specialists that he may be stating this to deflect scrutiny. 93. In the respect of the CTO, it was emphasised that this is a coercive mechanism that overrides the defendant's personal autonomy in regard to treatment, including, if necessary, enforced medication, as well as potential changes to his liberty, such as being required to attend particular places at particular times to be examined. It also allows for medication to be given without consent and for further oversight by the MHRT if there is a lack of cooperation with the requirements of the CTO. Police can become involved to detain the defendant and take him to hospital for enforced treatment. This is what Matthew Reason was hoping would happen, given the actions that he's progressed through in a bid to try and get somebody labelled as something they're not, because they may or may not be a threat to the legal position that Matthew Reason believes he stands in. 94. The Commonwealth recognizance was said to also provide a level of supervision in the community. It involves a referral to complete the EQIPS foundational program to address generalized offending behavior, a referral to a psychologist for assessment and implementation of strategies to address, among other things, his mental health and ideologies associated with the UKOA. Referral to the, quote, proactive integrated support model, end quote, of Corrective Services New South Wales, as well as to the CS New South Wales Terrorism High Risk Offenders Unit for offence-specific intervention and to monitor his engagement with community corrections. These things would be more than sufficient to deal with any risk presented by the defendant. So the Justice has pointed out quite a lot of failures on behalf of the state in their fear of this organisation and this jumping the gun to attack it, and then an attempt to undermine the very premise of it with the belief that it has disseminated and people have gone over to other groups. There is a legal precedence that has been put on the table here that the Justice is very well aware of, and that has caused the comments in the previous video in relation to the curial aspect of what it means to be the state. 95. The criminal history comprises relatively minor summary offences. A neighbourhood dispute should not be described as, quote, serious, end quote, in the context of an application for orders based on the potential for terrorism. The presiding magistrate made positive comments regarding the hope that the defendant could return to his family and resume work. He took into account the defendant's mental health issues and tailored the sentence in a way that assisted the defendant to be provided with rehabilitation, to be supervised by community corrections upon his release. Nothing was said by the magistrate suggesting that he thought the defendant was a terrorist risk. Just note the words that are highlighted. 96. The plaintiff's submissions that the defendant's beliefs are commitments support potential engaging in terrorism activities are speculative and rely upon the speculative proposition that the defendant's mental health will deteriorate. This ought not to be the conclusion reached by the court given the CTO. 97. The risk the plaintiff argues is presented by the defendant is also premised on the need for a prior narrative shift to create perceived legitimacy for violence. There is simply no evidence as to when or how that narrative shift would occur, and so really is no material upon which the court could find the circumstances that would underpin the reality of any risk presented by the defendant would occur, let alone it being considered to be an unacceptable risk. In other words, the police are full of shit. 98. The offensive material said to be material that advocates violence and amounts to a, quote, call to arms, end quote, to followers of the UKOA seems to be a somewhat cynical submission, given that there has been no application by the state or police for the defendant's Facebook or YouTube material to be taken down, despite there being various ways this can be done. 99. In an end result, what the plaintiff argues is not that the defendant intends to encourage or foster others to commit a terrorist act. There is no evidence that he holds or has ever held such an intention. The highest the plaintiff's case rises is that his videos might, underlined, lead some people to commit terrorist acts. This has to remain an uncalculated, unevidenced, speculative risk which cannot, on any analysis, satisfy the court to a high degree of probability that the defendant poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order.